Sri Arjun Ram Meghwal, Honorable Law Minister, Mr. Falias Nariman, Senior Advocate, Mr. Mahesh Jethmalani, Senior Advocate, Mr. Sham Devan, Senior Advocate, Mr. Gurumurthy, Mr. Kartikeya Sharma, Member of Parliament, Mr. Goswami, ladies and gentlemen. Today, I must say, without any kind of hesitation or innovation, that it's a great day. I always appreciated late Ram Jethmalani for three fundamental, perceptible reasons. In the year 2011, Mr. Nariman, Mr. Jethmalani, and myself shared a platform in the university. I quoted two lines from a Sanskrit prescription on how a plane should be drafted. I had translated it into English. Late Jethmalani asked for a copy and told me, I am not asking you just like that. I want to feed my curiosity. That was the great intellectual curiosity of late Jethmalani. The young students or the young lawyers who are present here today must understand and try to develop the intellectual curiosity. In that speech, he spoke a line. Whatever I do with a clear conscience. Look at the courage of the man. Third, whatever I have read and learned by meeting him, he had an incomparable presence of mind that epitomized originality. Today, with the Centenary lecture, I feel proud and honored to be a speaker here. Presently, let me focus on the topic. Has the basic structure doctrine served the nation itself? Nation well. According to the scientists and the rationalists, if you pose a question, it is fundamental to proceed in an empirical manner, and then only you will get a correct answer. Having scanned the anatomy of the question, which has been extremely intelligently framed by Mr. Mahesh Jethmalani, the answer should be given with utmost immediacy. And the answer is, ladies and gentlemen, a capital yes. It has served the nation well. To elaborate, the basic structure doctrine has served the nation and saved and stabilized the constitutional democracy and the core values with excellent solidity and virtuosity. I deliberately add this word, virtuosity, without allowing any space for doubt. Why do I say so? I cannot make a statement if they dixit and rest. I am obligated as a student of law to give reasons. When any doctrine is discussed, it's necessary to pose three questions. Firstly, the validity of its origin. Secondly, serviceability of the same for the cause it's conceived, and thirdly, necessity of its continuance tested on the progressive parameters without adopting a doctrinaire pedantic approach. Before I proceed to state the justness of the doctrine, the origin of it, which I would like to call cause of the cause, or for that matter, essence of the essential, has to be kept in mind. It is the summum bonum of our constitutional jurisprudence. That is, the Constitution is sovereign and its supremacy is unquestionable. There is no necessity to think that the judiciary is trying to reign supreme. Judiciary functions under the Constitution and follows the constitutional values, norms, conventions, framework, silences, or abeyance. Let's go in the history for a moment. Initially, the Supreme Court understood Article 368 in the literal sense. The real test arose in Gorakhnath, where court had to deal with many an amendment. Prior to that, two learned judges had expressed strong dissent in Sajjan Singh. In Gorakhnath, the view the court took eventually led to spate of amendments and gave rise to Keshavanand Bharati's case. The principle laid down there is well known. Because of prolixity of judgments, a senior counsel wrote a book and got it released in 2011, stating that the majority view in Keshavanand Bharati is not the ratio. I must tell you, the view is totally wrong. The ratio is absolutely clear. The Parliament has the power to amend the Constitution, but the power is not unlimited. It doesn't have the power to amend the basic structure of the Constitution. The majority of the judges also discussed some of the features of the basic structure doctrine. They can be encapsulated as rule of law, supremacy of the Constitution, democratic form of government, judicial review, independence of the judiciary, separation of powers, the secular and federal character of the Constitution. It was stated that the basic features are easily decipherable from the entire constitutional scheme. I really don't understand why the learned senior counsel and many others still think the ratio is not clear. Scrutinized oppositely, three aspects emerge. Firstly, the majority view is clear as day with regard to the nature and character of Article 368 of the Constitution. Secondly, given the power to amend, the article cannot be taken recourse to, assume unlimited power, or destroy and abrogate the Constitution, or to put it differently, in exercise of the said power, the identity and personality of the Constitution cannot be altered. Thirdly, the Constitution being supreme document, the basic features are unamendable. The interpretation is within the keen understanding of the Constitution. It's neither extra-constitutional, nor alien to the Constitution, nor meta-constitutional. It encompasses every facet of the Constitution to establish the ground norm, that is, unchangeability of the identity of our organic Constitution. All of you, I assume, must have gone through this decision. I am compelled to say, being intellectually bound to my concerns, that the origin of the doctrine is flawless. Chief Justice Sikri quoted a passage from the decision in Reed versus Baldwin. Look at the poetic prose. It states, in modern times, opinions have sometimes been expressed to the effect that natural justice is so vague as to be practically meaningless. But I would regard them as tainted by the perennial fallacy that because something cannot be cut and dried or nicely weighed or measured, therefore it doesn't exist. I can speak with certitude. All of you present here and all of the members of the great country, the citizens, and who are not there, can never say now that the principle of natural justice is vague. Any lawyer worth his salt will always argue natural justice cannot be ignored. Similarly, basic structure doctrine can never be ignored. How to test a doctrine? The correctness, acceptability, serviceability, and the solidity of any legal theory is put to test when the occasion arises. The basic structure doctrine did not have to wait long. In 1975, Article 329A by 39th Amendment came into existence. The said amendment made an, shall I say, adroit endeavor or maladroit effort to immunize the elections of the Prime Minister and Lok Sabha Speaker from scrutiny by the judiciary and further to nullify the judgment of the Allahabad High Court. The Constitution Bench, presided by the Chief Justice N. Roy and Indira Nehru Gandhi, said that the court was proceeding with the hearing on the assumption that it is not necessary, I repeat, it's not necessary to challenge the majority view in Keswanand Bharati's case. I must say and remind this House, it was eventual acceptance by the non-believer in basic structure doctrine. I'll refer to another amendment, Mr. Nariman has dealt with it in a different way, that came in quick proximity, the 42nd Amendment. It had been brought with the intention to reduce the power of judicial review, to treat the directive principles of state policy to a primacy over fundamental rights, and further asserting parliamentary supremacy or parliamentary sovereignty by state, stating that no constitutional amendment can be called in question in any court on any ground. By the said article introduction to 368, all fundamental articles, if I am permitted to say, went to the Arabian Seas or the Bay of Bengal. They fell into insignificance. The harmony between Part 3 and Part 4 of the Constitution was destroyed. When challenged, Chief Justice Y.B. Chandrachud in Minerva Mills case said, since the Constitution had conferred a limited amending power on the Parliament cannot, under exercise of that limited power, enlarge the very power into an absolute power. By the 42nd Amendment, the real essence of the Constitution was destroyed. The court did the needful. Mr. Arnab Goswami raised a question today that should be a debate. I must ask a question to everyone and every curious student of law. What would have been the fate of this nation and its citizens had not the court taken aid of the basic structure doctrine and declared the disturbing part of 39th Amendment and wholly unacceptable and devastating amendment occurring in 42nd Amendment as unconstitutional. The result would have been the cherished ideals and marrows of democracy would have been guillotined, and the nation state would have faced, to quote a phrase from great John Marshall, a solemn mockery of the Constitution. And more significantly, the real judicial review would have melted into nothingness, and the citizens of this great democratic polity would have turned into subjects. I hope all of you understand the distinction between a citizen and subjects. I must refer to NJSC case. All of you know the amendment was struck down as that infringed the judicial independence, which is a basic structure of the Constitution of India. In I.R. Coelho case, the 9 judges unanimously said, you cannot put a legislation in the 9th schedule and say it is human. What has it actually done? If you go deep, think deep, it has really empowered the citizens of India not to suffer an impermissible law because of grant of immunity. An impermissible immunity. Now let's come to the rights test. The rights test and the concept test have put the individual rights and constitutional values on the elevated platform. The citizens' rights recognized under the Constitution, according to me, can never be marginalized, and it would not have been possible without the basic structure doctrine. Since that every individual right would have paled into total insignificance. There would have been no expansion of Articles 14, 19, and 21. The apex court could not have propounded the values of individual dignity, privacy, choice, freedom of expression, equality in the true sense, gender rights, constitutional tort, and other aspects, all founded on acceptable, realistic constitutional principles. The entire nation state would have paved on the path of regression, and the citizenry rights would have gradually moved into unredeemable hollowness. There can be no scintilla of doubt, no trace of doubt, no speck of doubt that the basic structure doctrine stabilizes constitutionalism, constitutional governance, rule of law, and legitimizes all actions. Let it be told today that the basic structure doctrine is one that is directed against anarchy. It has basically acted a navigational compass to enable the judges to navigate the journey of constitutional interpretation in the proper direction, and also guided and enriched our constitutional progress. It is the elan vital and the filament of the constitutional principles and values. In conclusion, I would like to say that the basic structure doctrine is neither an enigma nor in the realm of mysticism. It is here in the elements with true fixed continuing quality. I repeat, it is here in the elements with true fixed continuing quality. Why? To serve, protect, and shape the nation, because it is the spirit, fundamental essence, and conscience of the Constitution. None of us should forget that basic structure doctrine remains the most natural constant. I borrow these words from physics. Natural, constant, and diligently searched rock. I borrow these words from philosophy. Diligently searched rock of our constitutional democracy and philosophy. Never mortgage our constitutional democracy. Never, never barter it. Thank you. Thank you very much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.